Welcome. Thank you all for being here. My name is Katie Brennick. I am the Training and Development Coordinator here at School on Wheels. I want to thank you all for joining us today for our webinar on the special education rights of foster youth and youth experiencing homelessness and how to advocate for them, especially right now as COVID-19 is closing schools and really affecting learning. I think this is a really important topic for our students right now, very, very salient. As we all know, they're going through a lot. And we are extremely lucky to have Jill here with us today. She is going to bestow upon us all of her wisdom. Yeah, so Jill, if you wouldn't mind just taking it away and introducing yourself.
You got it. So hello, everyone. Good afternoon. My name is Jill Rowland. I'm the director of the education program at the Alliance for Children's Rights. The Alliance is a nonprofit legal services organization serving children living in out-of-home care in LA County. We also do policy work at the local and state level as well. I'm going to tell you a little bit about our organization and all the different types of services we provide, and then we'll dig right in on all of our education work. So if you are working with kids who are in the foster care system or who are in the juvenile probation system, all of our services are available. For example, our education work that we're going to talk about today. We also do financial benefits work for those kids, and that if a kid is involved in either of those systems and is not living with their biological parent, most of those kids have a right to receive some type of financial benefit from the county, the state, or the federal government in order to pay for the care of that child, clothes, housing, different things like that. We also work with those kids to make sure they have access to the health care as well as the mental health services that they need. So if you're working with one of those kids and they're having trouble getting into therapy, getting their medications, getting braces and things like that, and we also work with youth who are transitioning out of that system. So between 16 and 24, we help those kids, apply for financial aid, get into college. We help with housing for those youth. We work with youth who are pregnant or parenting. We deal with kind of consumer fraud issues for those youth. And then our last program specifically is open to kind of anyone in the community. And this is our legal guardianship program. So if you are working with a child who is not living with their biological family, but is in a safe and stable home, there's no need for them to go into the foster care system. Maybe they're living with an aunt or a grandmother. But there's no legal relationship between that caregiver and that child. So that caregiver may be having trouble accessing education for that kid or accessing healthcare for that kid because they don't have the legal authority to do so. We can help seek legal guardianship through the court system to legalize the relationship between the parent and the caregiver, so the youth and the caregiver, so that caregiver has all the rights they need to access services for that child. In order to get any of our services, there's two easy ways to do it. The first one is to call our intake line, and it's open and manned by volunteers during working hours. Currently, because our office is closed like everyone else's, you call, leave a message, and then someone will get back to you. And then you can also go on our website and do an online referral. And what I will do is I will put our phone number and our website in the chat box for everyone so that you have it. So while I do that really quickly, I want to let you all know I'm so excited to be here with you guys today. We are going to be talking about the education rights of kids, and we're going to discuss both general ed and special ed, and I'll delineate exactly who has these rights and how to access them. And welcome and love all of your questions. I'm happy to take those at any time. We are going to ask that you put those in the chat box so that I can see those come in and answer them as they come. So I'll pause for just a second to see if anybody has any quick questions coming in through the chat box about my agency, about how to refer kids to us. And while I give that a second, I'm going to go ahead and share my screen so you all can see the tools that I'm going to be using today. All of our tools are available in English and in Spanish. They are on our website, but I'm also happy to send those over to Katie to send those around to you all. And these are designed to be caregiver and youth friendly. You'll see as we go through them, there's lots of pictures. They're very colorful. We try to use language that can be accessible to everyone. So that is one of the things that we try to do to make the materials accessible to the people that are trying to use them. All right, so I'm going to start with general education rights. And the reason why I'm going to start here is a couple of things. Number one, this is going to be kind of most widely available to the students that you are working with. And these are rights that typically people don't know about. And these rights can be really important for our kids and our families. So this handout says foster and probation youth, but the rights that I'm going to discuss today apply to foster probation youth, also apply to youth that are homeless. And then there's a list of additional students that this applies to. So kids living in military families, kids that are living in migrant families, newcomers, and I think there might be one other category that I am forgetting, but definitely apply to foster probation and homeless. So these rights apply to all of your students. So the first rights we're going to talk about are enrollment rights. And one of the reasons why, it's really important to talk about where kids go to school and where they have a right to go to school. Many of our kids are very disengaged from school. I'm sure you guys know that, you're working with them because the school has pushed them out. Or they've had discipline issues, or they're very unstable. And so they're coming to you guys for services and tutoring and education stuff. And so, in general, kids in the foster care system move an average of 8 times while they are in care. And that instability leads to kind of a significant lessening of their ability to access their education. So at every move, kids can lose up to 6 months of their education. If on average, they're moving schools 8 times, that's putting them 4 years behind their peers. We also know that about 83% of kids are retained or held back by the time that they reach 3rd grade, and kind of across all measures, whether it be state testing, chronic absenteeism, school discipline, or graduation. Our foster and probation, as well as homeless youth, typically perform far worse than a typical student peer in California. And so we talk about enrollment, and really what we want to talk about is school stability. So kids have a right to attend their local school unless, number one, they have an IEP that requires them to attend a different type of school. Number two, they've been expelled after a formal expulsion hearing. And that's a little bit different than, oh, they told me I can't come back here. That's not a formal expulsion. That's an involuntary or an informal school push out. When we talk about a formal expulsion, that means there's a hearing and kids can present evidence and be represented by an attorney, and then there's a formal decision by the school board. That's what I mean when I talk about expulsion. Or if a kid is in a juvenile hall or a camp, they obviously cannot attend their local school of residence. When kids come out of a hall or camp, they 100% have a right to go back to that local school, again, unless they have an IEP that requires a different placement, or they've been formally expelled. Our kids cannot be forced to attend continuation schools, adult schools, or independent study schools, schools for pregnant and parenting teens. Even if they're off track for high school graduation, they have failing grades, they have discipline problems in school. None of those things allow school districts to force kids into alternative school settings. Now, a child's education rights holder, and I'll define that a little bit in just a few moments, can choose that one of those alternative school settings is best for a kid, but a school or a school district cannot force a student into that school, again, unless they have an IEP that requires that type of placement or they've been formally expelled. Now, for our kids, again, homeless, foster, probation, who are moving because their home placement is changing or because they become homeless or they're moving shelters, for example, these kids have a right to attend what's called their school of origin. And school of origin has three potential definitions under the law. The first definition is whatever school they attended when they were first removed from their parents into the foster care system, when they were first removed from their parents to go into the juvenile justice system, or whenever they first became homeless. Kids have a right to go back to that school. And it doesn't matter how long ago that was. It doesn't matter what was kind of happening with the child at that time. They have a right to go back to that school. This right also includes the right to follow what are called matriculation or feeder patterns. So if I'm 16, but I was removed from my parents when I was in kindergarten, as a 16-year-old, I'm obviously not going back to kindergarten or back to elementary school. But most districts have feeder patterns. So all the kids in that elementary school kind of feed into a specific middle school, and all the kids in that middle school feed into a specific high school. That high school that follows that feeder pattern becomes my school of origin. And the reason for that is we want to get those kids back into kind of their peer group. The second potential definition of school of origin is just the last school the youth attended. Again, it doesn't matter how long ago that was. It includes that matriculation or the feeder pattern rights. And then the third option is any school that the youth attended in the last 15 months where the youth felt a connection. And that could be anything. That could be they had a boyfriend there, they had a favorite teacher there, they liked the art class there. As adults, we don't judge what that connection is. The youth just has to say that they feel a connection to that school. And that one is the only one of our three options, which is time limited. The child had to go to that school in the last 15 months from when you're trying to re-enroll in that school. What else do I want to say about school of origin? School of origin, I think during COVID is really important. Especially, you guys, I think all know as we do as adults and professionals, connecting remotely via Zoom and other platforms can be difficult. And for a new student, it could be especially difficult to try to make connections with peers and with teachers to try to kind of embed yourself in a school that's brand new to you through these remote access options. And so I think school of origin is really, really important these days for our kids. Now, once we get out of remote learning, which, at this point, maybe this school year, more likely next school year, then we run into an issue around transportation. What are your transportation rights? How do you actually get a kid back to their school of origin? And there are a couple of options, and these do depend on kind of what your eligibility is. So for example, if you are a homeless student, it's the school district's responsibility to get you to your school of origin. If you are in the foster care system, there's a couple of different ways to get kids transported to their school of origin. The first way is that the caregiver can actually be given a financial amount of money to drive the kid back and forth. And that's not always an option for kids and for caregivers. Maybe there's multiple children in the home that are all going to different schools, but that is one option. And that becomes part of the financial benefit going into the home. And the way to kind of get that is to apply through the social worker. There are lots of reasons why that application process goes wrong. And as with everything we're going to talk about today, if you experience any issues in accessing any of these rights, that would be a great reason to give us a call, go through our intake process, and let us help you. The other way that kids in the foster care system can be transported to their school of origin in LA County is there is a kind of Uber for Kids rideshare option called Hop, Skip, Ride. And not all districts in LA County, because there's 80 of them, have signed on to this program yet, but a lot of them have. And that's another option as well. This stuff can get a little complicated and can be difficult to access. So again, if you are attempting to kind of access these rights and you're having difficulty, please give us a call. We'd be happy to help. So do youth also have a right to be immediately enrolled in and attending school, even if they don't have any of their required documentation that's required for other kids? Transcripts, immunizations, proof of residence, IEP documents. Our kids have a right, again, to be immediately enrolled and attending school. Now, I've heard a lot of people say, well, immediately means 3 days. It does not. Immediately means immediately. There's nothing in the law that says immediately means 3 days. And so how I interpret that as a lawyer and as an advocate is that, typically if you walk into a school and you ask to be enrolled, you have a right to fill out the paperwork and the kid has a right to be in class that day. In COVID, what I think that means is you have a right to contact the school, and the day that you contact the school, you have the right to do what is, fill out the paperwork that's required and get that kid, get them their technology, go pick up the laptop or whatever and get them in classes and working that day. What's also important for our kids, especially for our high school kids, is they also have a right to be enrolled in the same classes they were taking at their old school, even if kids are moving right in the middle of the semester. And the law actually says the same or equivalent classes. So let's talk a little bit about what that means. Obviously, if you're in Algebra A, you have a right to be enrolled in Algebra A at your new school. But there are some classes that are somewhat unique. So I'll give you kind of a silly example. If school A has underwater basket weaving and school B doesn't have underwater basket weaving, what do you do? This is where we get into the equivalent. And we interpret that to mean meeting the same graduation requirement. So if school A had the child in underwater basket weaving and had that as a visual performing art, the child has a right to be enrolled in a visual or performing art at school B. If school A, on the other hand, had underwater basket weaving as a PE class, then the child would have a right to enroll in a PE class at school B. The point here is that we're trying to get a kid a full semester or 5 credits of the same class, or a class that meets the same graduation requirements that would allow the student to be able to get those full 5 credits. All right, so here are just some suggestions. What do you do to protect your rights? We want our kids and our families to work with caregivers and rights holders, social workers, probation officers. Also, at every school district, they have someone who is either the foster youth liaison or the homeless liaison. That's a great person to get involved. They should know all about these rights, and it's really their job to make sure that these rights are protected. Again, I'll talk about this a little bit more in a minute, but an education rights holder is the person who makes the decision about what is in the child's best interest. So should they enroll at their local school? Should they enroll at their school of origin? Which of the potential school of origin schools is in the child's best interest? That's all the decision of the education rights holders to make. And then, of course, if you have some issues, you can contact us. We also highly recommend trying to meet with school counselors to make sure that children are enrolled in the right schedule of classes. And then records are supposed to be transferred from the old school to the new school. So that's something important to try to make sure that occurs as well. All right, and then we've got 2 more rights that apply to foster, probation, and homeless youth, specifically youth who are in high school. So the first thing we're going to talk about is partial credits. So this is relevant for youth who transfer schools mid-semester And it very often is the case when they move from school A to school B, school A doesn't issue them credits, and then school B doesn't issue them enough credits. And so they end up being credit deficient, even though they were in school doing the work. And so that can be a problem. We also have lots of kids that, because their records didn't transfer, end up taking the same class more than once, even though they already took it and passed it. And this also occurs when kids move from school A to school B and they're not put in those same classes. So these youth have a right to receive credit for all the work that they did at school A and all the work that they did in school B. So if a child was in school A for half of the semester and they got a passing grade, typically A, B, C, or D, and I'm just going to make up some numbers here to show you the example, but if they were there half the semester, they have a right to 2.5 credits in every single class that they received a passing grade in, issued by school A. And they have a right to receive 2.5 credits from every single class that they had a passing grade in school B. And then we, of course, hopefully put that all together and it ends up being 5 credits per class. It's also really important to know that schools cannot force kids to retake a part of the class that they already took, especially if it would throw them off track for graduation. And again, they have a right to be enrolled in the same or equivalent classes as those that they were in their prior school. So we just have a little checklist here before you leave your old school. You know, it's helpful if you can to make sure the child is officially disenrolled, to make sure they get a grade from each class, even if they're there for only a short amount of time, and then to get a transcript, including those partial credits. Every district has to have a partial credit policy that says this is how this is how many credits you earn. If districts don't have a partial credit policy, there is a model policy in California that they can adopt. And the model policy said a kid only has to go for 7 school days to get a half a credit. So when we talk about, like, it doesn't really matter how long you went, you literally only have to go to school for potentially 7 days to get a half a credit. So this is one of the ways that we can help make sure our kids are engaged in school and are working towards high school graduation. So the last thing we're going to talk about in terms of general education rights are a special graduation option called Assembly Bill 167, Assembly Bill 216. It's also called the California Graduation Exemption. It has lots of different names that it goes by. But the basics are when kids transfer schools after completing their second year of high school. So basically they have to transfer sometime after completing 10th grade. And they're behind in credits and off track for high school graduation. And they're a foster, probation, homeless, military, newcomer, migrant, etc. student. If all of those things happen at the same time, then those youth have a right to do the state minimum graduation requirements. And that's 130 credits, as opposed to typically the 220 credits that are required by the school district. Now, it's not just any 130 credits, it's got to be some specific credits. And here is the list of those credits. So it's 30 English, 20 math, et cetera, et cetera. So these are the exact credits that a student has to have to graduate using AB 167, 216 graduation. Now, these kids have a right to remain in high school for 4 years. They also, if they don't want to do the state minimum graduation requirements and they want to try to do the district's full 220, they actually have a right to stay in high school for a 5th year. Even if they turn 19 years old. So that means that a kid can be in normal high school until they're 19 years and 364 days old. Obviously, when they get to 365 days old, they're 20. So that's at the point where they're not allowed to be in high school anymore. And so that's really important to know as well. Now, when a kid transfers into a new school, they have a right to be certified as eligible for this graduation option or not eligible for this graduation option within 30 days of enrolling in that new school. And the school district actually has to give written notice of that eligibility to the youth, the ed rights holder, and then their social worker or probation officer. Now, at that point, it's the ed rights holder's decision about whether or not doing that graduation is in the child's best interest or not. Okay, so these are our gen ed rights. I'm gonna pause for a second to see if we have any questions that have come up. So one of the questions that we had come in right after my intro was whether or not I know of any Ventura County agencies that do work like we do, and I don't, unfortunately. So I'm really sorry about that. So I will keep my eye on the chat box to see if we have any questions coming in about general education rights. And while I do that, I'm going to transition over into our special education manual. Okay, so we do have some questions here. If a student is attending a virtual learning academy and wants to switch to an in-person school within the same district, but has moved out of that district zone because they've switched shelters, what are the student's options? So that is a really good question. So if you're in a virtual learning academy, that would be a school of origin. And then if you want to go into a different in-person district school, that would be a new school. So that wouldn't necessarily qualify as a school of origin. But for homeless kids, they have some extra rights. And I'm not 100% of an expert in this, but it's my understanding that when you are homeless, kids basically have a right to immediately enroll anywhere, regardless of their residency, because we know residency switches all the time. So I think that that student would have a right to do that. But, and I'll be really honest with you guys about what is, what I know for sure and what I don't know for sure. That would be something that I would definitely check in with the homeless liaison for that district. Okay, so we have another question here. Third grade student and mother were moved from the homeless shelter to an apartment far away from the elementary school. If online schooling ends, can she get help with transportation to continue his school until the end of the school year or until graduation? So that's a really good question. Yes, number one, the child has a right to go to that school. That is a school of origin. When the right to school of origin ends, and that would include when the right to transportation ends, depends on how old the child is. So for kids in elementary and middle school, and that would be applicable to the question here, kids have a right to stay in that school of origin, including transportation support, until the school year ends, when their homelessness stops, or when their foster or probation case closes. So if the kid just moved, let's say over Christmas break, and their homelessness ended, they're now in an apartment, they have a right to stay in that school of origin all the way until the end of this school year. If a child is in high school and either their homelessness ends or their foster or probation care case closes, they have the ability to stay there until graduation. And the rules around transportation are a little bit different. The transportation right ends, but the right to stay in the school of origin continues, which is kind of annoying, but that is what the current state of the law says. All right. Oh, and that's great. You guys have a searchable database for all the homeless liaisons on the website. Thanks, Katie, for putting that in. All right, so now we are going to turn to special ed. And so Special ed applies to all kids, foster, homeless, probation, and any other kid who has a disability. So that's important to kind of let everybody know that right at the outset. So the first thing I'm going to talk about is education rights. And these are really important to talk about both in the general education as well as in the special education universe, because an education rights holder is someone who has the legal authority to make education decisions for a child. Now, in a typical situation, that is a biological parent, right? So just because you have a kid, that means that you are the education rights holder for that child. When we are working with kids in the foster or probation system, a court may limit those rights and give them to someone else for a variety of different reasons. It is also possible when kids are homeless that there may be unaccompanied minors, or in many ways they are just disconnected from their parents, and they need an education rights holder as well. Now, an education rights holder makes all education decisions. So they can request records, they make decisions about where kids enroll in school, they make decisions about graduation options, they make decisions about requesting assessments and consenting to assessments, and then requesting and consenting to IEP services. So there's lots of different things. Basically, education rights holders make pretty much all decisions for kids. So as I discussed, it's typically a biological parent. But education rights holders also include adopted parents. So if a child gets adopted, by law, that adopted parent now holds education rights. Also, legal guardianship. And this is not, have a notarized letter or anything like that. This is a legal guardianship awarded by a court that also automatically transfers education rights. When youth turn 18 years old, they also automatically hold their education rights. For everybody else, especially in the foster or probation system, a judge can limit the education rights of biological parents and appoint a new education rights holder via a court order. And those people can be foster parents, prospective adoptive parents, someone acting as a parent, for example, a relative caregiver. That can include CASAs or other types of court-trained volunteers. Sorry, guys, bear with me. I'm just navigating things around. And so if you don't know who the ed rights holder is for a child in the foster or probation system, we recommend that you ask the child's attorney or social worker or probation officer. There are lots of different instances when education rights can change. So, a parent may become incarcerated or, may just kind of disengage from the child welfare system. You can have kids that were in foster care but went back to their biological parents. That's another reason why kids may need their ed rights changed. When kids move from home to home to home, we talked about how unstable kids can be in these systems. You don't want 3 caregivers ago to hold education rights. They're probably not really engaged with that child's education anymore. And ultimately, any education rights holder, including parents who are unwilling or unable to continue holding education rights or are not making decisions in the child's best interest, those kids can have their education rights changed as well. If you are working with a child and you don't think their current education rights holder is working in their best interest, again, we recommend you contact the child's court-appointed attorney to see if that needs to be changed. In the case where, for example, for homeless youth who are unaccompanied minors, there's no court system involved, but that child also doesn't have a parent and doesn't have an ed rights holder. What do you do in that instance? For those kids, and specifically for those kids who have or who need an IEP, a school district has a duty to appoint what's called a surrogate parent within 30 days of determining that one is needed. And again, this is for kids who have an IEP or for kids who need an IEP. And so that is something that, you can definitely ask, like, hey, I have an unaccompanied minor who has PTSD, who needs an IEP. I'm putting you, school district, on notice that this child needs a surrogate parent. So you have to appoint with one within 30 days. And, depending on your relationship with the child, you could even ask that you be appointed the education rights holder. Now, I wouldn't do that without consulting your school on wheels staff to see if that's appropriate, but that is a possibility. All right, so I'm going to go back and answer a question around school of origin transportation. And at the same time, we're also going to pause to see if anybody has questions about education rights, while I also navigate to our special ed section. All right. Okay, so we had a follow-up question about our third grade student who was told that they can continue at school of origin until graduation, but not get assistance with transportation. So the law says kids in elementary or middle school can stay in school of origin until the end of the school year where their homelessness ended. It sounds like this school district is doing more than what the law requires. Remember, the law is always the minimum. School districts can always do more. So it sounds like in this case, the school district is doing more by saying you can actually stay all the way until graduation, which is fabulous. A school district is not responsible legally for transportation past when the homelessness ends. But again, if the school wants to do more, they can do that. So that is a good outcome, it sounds like, for that kid. All right, so let's talk about special ed. So the first thing to know is just that school districts have an affirmative duty called child find to seek out, identify, locate, and evaluate all children who have a suspected disability. And if they were doing their job correctly, everybody who had a need would have an IEP. Now, we know that that's not the case, but that is what their responsibility is. So the first thing we have to talk about is, how do you get a kid assessed for an IEP? So step one, requesting an assessment. The first thing to do is to request the assessment. We always recommend that those assessments be requested in writing, because in special ed law, we have a variety of different legal timelines that have to be followed. And if you've put the request in writing and you have proof that the school district received it, for example, a sent email or a fax transmittal sheet, you can enforce those timelines. And as an advocate, it is one of the most valuable tools that I have is catching districts who are not following the legal timelines, because then you can kind of force them to do what you want. Right here, I'm not going to click on it, but if you do click here, we have a tool that can be downloaded and used. It is an assessment request letter. It's got some directions on it about how to do it, and then you can actually fill in the sample letter and send it off to your school. So the number one thing you have to say in your letter is why you think the child has a suspected disability. And the reason for that is our legal standard. You have a right to an assessment if the child is suspected of having a disability. That doesn't mean you have to prove they have the disability. That's what the assessment is all about. You just have to have a suspected disability. Now, you may ask, how do you know what a suspected disability is? Well, there's lots of things that can demonstrate a suspected disability. Having poor grades can demonstrate a suspected disability. Kids who have behavioral issues, social emotional issues. Certainly, any child who has a diagnosis already has a diagnosed disability. So they, in my opinion, automatically have a right to an assessment. It doesn't mean they have a right to an IEP. It just means they have a right to an assessment. And anybody can request an assessment. So before I said ed rights holders pretty much do everything, this is one place where there's an exception to that. Anyone can request an assessment. Once the assessment has been requested, the school district has 15 calendar days to respond to that request. And they have to respond in writing. And they have to respond by either granting the assessment or refusing to do the assessment. And there's only one reason why they can refuse to do an assessment. They have to be able to demonstrate that the child doesn't have a suspected disability. So let's talk about some really common things that happen that are illegal. So you request an assessment and the school district calls the family and says, well, your kid is doing okay. They're not doing that bad. Why don't we talk about it at parent-teacher conferences in a month? Why is that illegal? Well, number one, the response was not done in writing. Number two, they didn't give any evidence for why the child doesn't have a suspected disability. And number three, they're kind of kicking the can down the road and saying, let's talk at parent-teacher conferences in 30 days. So that violates the 15-day rule. Another really common response, well, it's our district policy that we do 3 SSTs, typically called a student study team meeting, before we do an IEP. Again, we're kicking that can down the road. There's nothing that's demonstrating that there's no suspected disability. They're saying we're going to respond to that after 3 SSTs. All of that's illegal. So one of the most powerful tools that I use as an advocate is I do my assessment request letter, I wait out the 15 days, and then I call them on day 16 and say, oh, you haven't responded in writing, you haven't said you're going to agree or disagree, so now you have to do the assessment. And it's shocking how that works. What's important here is you have to keep the letter that copy the letter that you sent. You got to keep proof of the day the school got it because you have to be able to prove your 15 days. And that all works great. Couple of caveats here. When there is a school break that is longer than 5 days, the 15-day timeline stops. So a really common example, if you requested an assessment the day before school went out for winter break, you don't count winter break, right? You can count the last day, that Friday, as day 1. And then if schools go back next Monday, then that's day 2. Also, lots of districts, especially LAUSD, like to do this really tricky thing where they do spring break plus Cesar Chavez Day. That makes it a 6-day break, and those days don't count as well. Otherwise, it's calendar days. So that means all days, weeks, weekdays, weekends, all those days count. So today is the 6th. If I asked for an assessment on the 6th and school was in session, they would have to respond to me by the 21st. Okay, let's talk some COVID specific stuff. So first of all, it's important to note that when schools closed down in March, the legislature and all of their kind of amazingness decided to take this 15-day timeline and say, we're not going to do that right now. So they actually changed the law. So from March until about the middle of September, our 15-day timeline disappeared. And so that took away one of our most important tools. The good news is, as of the middle of September, the 15-day timeline is back in effect. And it actually, the law, don't ask me why, but the legislature backdated it and said, oh, the 15-day timeline was actually back in effect as of June 30th. And I know this is kind of confusing. Basically, all you need to know is this is good law. The school district has to respond in 15 days. So we got a question, when you say in writing, is it written and mailed to the school district and then family, or can it be completed via email? It just has to be in writing. So email is great. I love email. You can have proof that it was sent. You can even ask for that little, check to get the mail received thing. And the district can certainly respond in writing via email. But remember, their response can be only one of two things. Either, yes, we're agreeing to do the assessment and here's the assessment plan, or no, we're not agreeing to do the assessment because your child doesn't have a suspected disability because blah, 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 with actual reasoning. Okay, so that is the first thing to know about COVID with special ed, is that the 15-day timeline is in effect. So follow-up question, it doesn't have to be handwritten. That is correct. It just has to be words on a piece of paper. So it doesn't have to be written by hand. It can be email, it can be typed. It could maybe be hieroglyphics, right? It just has to be words on paper that are, can be transmitted somehow. So snail mail is okay, not preferred, because you can't prove when a school district got it. Fax is fine, email is fine. All of those things count as being in writing. Oops, sorry, went a little bit too far. Okay, so there's lots of different type of testing that can occur. The most common type of assessment is called a psychoeducational assessment. And that's going to look at how does the child's brain work, where are they academically, how do they process information coming in through their eyes and their ears, kind of what are the basics on how things are going socially, emotionally, and behaviorally. That's another option as well. And then they'll also look at health and physical development. So that's all part of one assessment called a psychoeducational assessment. But there's a variety of other types of assessments that you can request as well. And depending on your child's needs, you may want to request specific other assessments. That can be a speech and language assessment for a child with speech delays, auditory processing, visual processing, occupational therapy. If you have a child with really intense emotional needs, you might ask for what's called an educationally related mental health services. You can also request, if a child has significant behavioral needs, you can request what's called a functional behavior assessment. So that's another option as well. Now, one of the questions that is very, very relevant during COVID is, well, kids aren't going to school, so how do they get tested? And we can talk about this both in relationship to what the law requires, as well as like what's practical and reasonable and feasible. So a couple of things. A comprehensive assessment has to include 4 different things: standardized testing, classroom observations, interviews with caregivers, ed rights holders, teachers, etc., and a review of school records and work samples. So I think number 4 is pretty easy, right? Like school records exist, work examples exist, those can be reviewed. Also, number 3, relatively easy to do. Interviews with caregivers, ed rights holders, and teachers. Those typically don't even always happen in person anyways. They typically happen on the phone. So those can still be done, even though we're in the middle of a pandemic. Number 2, a little bit harder, but I think still possible. There is a classroom. It might be a Zoom classroom, but there is a classroom that's going on. And, a school psychologist, for example, could sign into the classroom and could observe what's going on with that child in that educational setting. So a little bit harder, but I don't think that there's any reason why that can't be done. So what we're left with is standardized testing. And this is where all the fight has been about these days. And there's been a lot of fight. There's lots and lots and lots of districts that are still not doing testing of kids. And this is really problematic. So number 1, there's nothing under the law that allows a district to not test kids, meaning that districts are responsible for testing kids throughout the entire course of the pandemic. So that's what the law requires. Now, this can be, we have clients that were like in the middle of an assessment timeline, and the school district stopped testing them. Kids also have to be tested every 3 years. We have lots of kids who had their triennial or every 3-year assessments due that didn't get them. We also have kids transitioning from the regional center system into the school district at age 3. Those kids were not tested. So school districts basically just shut down testing altogether, and that was illegal. So we also have to think about what's realistic and practical, right? Because we're living in a pandemic, we have to keep everybody safe. So testing by law has to be both valid and reliable. So valid means we're testing what we say we're testing. Reliable means if you gave the kid the test multiple times, you get a pretty similar result. And in standardized testing, and the reasons why it's called standardized testing is there are kind of set protocols for how you test a kid. So, for example, there's some tests where you're allowed to repeat the directions, and other tests where you're not allowed to repeat the directions. And based on how they designed that test and how they standardized it and normed it across all the different kids, if you quote unquote break standardization by not following the testing protocol, then the test becomes invalid and unreliable. And so lots of districts said, well, we can't do testing remotely because then it's not going to be valid and reliable. And that worked for March and April and maybe a little bit of May. But our test makers were really amazing. And they actually went out and re-standardized their testing using remote testing criteria. So they figured out how to give these tests and give them in a standardized way. And they actually published new protocols that allows for online or remote testing. And so this idea that you can't give standardized testing remotely because it's invalid and unreliable is now, total malarkey, basically. So that can be done. So that's option one, is to test kids remotely. Option two is to test kids in person. In September, the state of California came out with this guidance called, typically referred to as the small cohort guidance. And what the guidance said was that you can bring back high needs kids at a ratio of 14 kids and 1 adult or less, as long as you only have a really small number of kids. I think it was like 10% or something of kids on campus. You can bring those kids back and you can serve them in person. And of course, you have to do, temperature checks and masks and all those other different things. But the state said, in compliance with CDC guidelines, that kids can, small groups, small cohorts of kids can come back to school. And lots of districts chose to use that small cohort guidance to bring kids back one-on-one. So it's one kid, one adult, they may be in a room separated by a plexiglass shield with masks, with hand sanitation, with temperature checks, and you can actually bring those kids back in person and do testing in person. So it's important to know, number one, kids have a right to be tested. And number two, there's both online and in-person testing that can be done with validity and reliability and can be done safely. So probably everybody out there who's tried to get a special ed assessment since March has probably, or their family has gotten a letter saying, oh, sorry, we can't test, not valid, not reliable. And I'm here to tell you that's a load of malarkey. Now, if you're in that situation and you've had a refusal to assess, or the district has kicked the can down the road and said, we'll test when school's back in session, those are the types of cases you should definitely be sending our way. We're doing a couple of things around this. So number one, we are working with individual kids, and we are filing complaints at the state level to force testing. And we've won every complaint that we have filed so far because kids have a right to be tested right now. So if your kid needs to be tested and they're not, and you need help, please come our way. Let us help you. Number two, we've also done a class action litigation against specifically LAUSD because they are specifically refusing to attest all kids. And so, you can learn about a little bit more about that. We've got declarants, meaning families that desperately need their kids to be tested, or even to go back in small cohorts to go back to school. Think about like really high needs kids, like kids with really severe autism. They can't learn in a remote environment. They need to be back in school. So we have those kind of options available. Okay, I'll take a breath, see if you have any questions about assessments. But I'll also kind of tell you while we're waiting to see if any of those come in, assuming a district agrees to test a kid, the district within those 15 days has to produce what's called an assessment plan. And the assessment plan says, yes, we agree to test your kid, and we agree to test them in these areas by these specific people. So typically they check like cognition, academics, social emotional, all by a school psychologist. That's a psychoeducational assessment. If they also, for example, check language by a speech and language pathologist, then you know you're also getting a speech and language assessment. Once an ed rights holder signs the assessment plan, and nobody else can do it, just the ed rights holder, giving the school district permission to test the child, and that assessment plan gets back into the school, again, strongly recommend you fax or email that so you know when it got in. Then the school district has 60 days, 60, to do all of the testing and hold the IEP. And that's another really important timeline that is getting blown right now, but you have the right and ability to enforce. Okay, so I mentioned this before, but kids can be tested every 3 years, or kids must be tested every 3 years. They actually can be tested once a year if requested by the ed rights holder. And if we're working with kids who have kind of severe ongoing academic delays, we will sometimes get our kids tested academically every year. Okay, so unless I see any questions coming in, which I have not, the next thing we're going to do is talk about the IEP. So an IEP is an individualized education program. It is a written document that is an agreement between the school district and the ed rights holder that says and guarantees what a child has a right to. And there are 5 main components of the IEP: eligibility, present levels, goals, placement, and services. And we are going to go through each of those. So let's start with eligibility. There are a variety of different eligibilities that kids can get special ed services for. And we only look at eligibility after the assessment. I can't tell you how often I hear from districts, well, we're not going to assess a kid because they're not going to be eligible because blah, blah, blah. Or they haven't been here long enough, or, you know, a variety of different reasons, or they didn't go to school until they were in 4th grade. So they're not going to be eligible, so we're not going to test them. That's illegal. We only look at eligibility after the child has been assessed. If you have evidence to prove suspected disability, you have a right to an assessment. And then once the assessment has looked at all the different factors, if we end up with, okay, this kid doesn't have a disability, they just didn't go to school for the first, 4 years of their education, then that kid is not eligible. But we have to look and see, is there a learning disability? Is there a visual impairment, et cetera, et cetera. So I'm not going to go into eligibilities in a large amount of detail because we have another tool right down here called our eligibility checklist, where you can learn more on that. The eligibility checklist is great. It goes through kind of our top, I think 5 or 6 eligibilities, tells you exactly how to get eligible under them. But the other really important thing it does is it talks about how to read and interpret standardized testing. And if you've ever read a special ed assessment, there's lots of numbers in there, and those numbers are kind of scary and overwhelming. And schools, when they explain the results of assessments, aren't very helpful in kind of taking that scariness away or making them easy to understand. Our eligibility checklist attempts to do that. So highly recommend you go and check that out. I'm going to talk not about all the eligibility categories, but just about a couple of them, kind of our most common ones. So let's start with other health impairment. So other health impairment, or OHI. To be eligible under that category, a child has to have some type of chronic or acute health issue that causes limited strength, vitality, or alertness that negatively impacts the child's ability to access their education. So if you haven't guessed already, one of the things or disabilities that falls under this category where lots of kids get eligible is ADHD. It's a chronic or acute health issue, causes limited strength, vitality, or alertness, which makes it difficult for the child to access their education. You can also do other kind of health related things under OHI. For example, PTSD can make a child eligible under this, and other just general health, cancer, different things like that. Also talk for a minute about emotional disturbance. I hate the language of emotional disturbance. I really wish it just said emotional disability. That would make me a lot more comfortable. So it's a bad name, but it's actually a really important category. In order to be eligible under the category of emotional disturbance, there's a couple of different kind of subcategories that you can fall under. So one is pervasive symptoms of unhappiness or depression. A lot of our kids may have that. That could make them eligible. Another one is inappropriate types of behaviors or feelings under normal circumstances. Now, I've heard lots of districts say, well, you only get that if you're hearing things that aren't there or seeing things that aren't there. Basically, you have to be hallucinating to get inappropriate types of behaviors or feelings under normal circumstances. That's not true. The law doesn't say that. The law says inappropriate behaviors or feelings under normal circumstances. So that can include PTSD. That can include pretty much any type of behavioral disorder. The other really common thing under there that kids can be eligible for is an inability to build or maintain satisfactory peer and adult relationships. So this can be kids who are defiant with their teachers, who have social skills issues. Lots of kids can be eligible, especially our kids, they're unstable, they're going through a lot of trauma. This is a really good category for them. You've got kind of other somewhat obvious things, deaf or hard of hearing, visually impaired or blind, orthopedic impairments, anybody who has trouble walking or needs a wheelchair or things like that. We've got autism, we've got intellectual disability. This is kind of formally known as mental retardation, and that requires standardized testing of cognition or intelligence to be significantly low. You've also got speech and language impaired for kids who are having issues with either how they articulate their sounds. This also includes fluency or stuttering issues, as well as kids who don't have kind of the vocabulary and the grammar skills necessary to put together appropriate sentences. Traumatic brain injury. This is, kids who had an actual injury. Maybe they were in a car crash or something like that. And then finally, specific learning disability. Lots of kids qualify as having a learning disability, and there's some kind of misunderstanding about exactly what that means or what that's all about. What's important to know with that is you actually have to be relatively smart to have a learning disability, because part of what a learning disability requires is a significant discrepancy between how smart the kid is, and then they have to be performing academically way below that. And so that's a really important category as well. So I'll pause for just a second, see if we have any more questions coming in about eligibility. Eligibility, again, is reviewed at the IEP meeting. After you have the assessment results, you go through them, and you're able to kind of figure out what is going on with the kid. All right, so let's talk about the different types of IEPs you have. So when you are first assessed, that's called your initial IEP. Once you're made eligible, you have an IEP every single year. It's required within 1 year of the initial. You also, every 3 years, have what's called a triennial IEP. It's the same thing as an annual, you just have new testing. A parent or ed rights holder or the school can request an IEP in between those annuals anytime they want. If there's just something going wrong with the kids' education, and that has to be held within 30 days of the request. I will tell you, this is a tool I've been using, me and my team have been using a lot lately. And we'll talk in a little bit about what's a distance learning IEP. But we have lots of kids who've not been getting their IEP services. And so we've requested amendment or addendum IEPs to discuss their distance learning. So that's a good tool to kind of keep in your back pocket. And then if you're working with kids who are unstable, any time a child moves school districts, the new school has to implement the old IEP as written to the best of their ability, and then hold a new IEP meeting within 30 days of the move to kind of figure out how to meet the child's needs and to write a new IEP in the new district. In terms of who should attend an IEP meeting, there are some required team members. These include the education rights holder, a general ed teacher, a special ed teacher, and what's called an administrative designee. Now, this is different than the quote unquote administrator. The administrator is like the principal. The administrative designee is the person who's been kind of tapped on the shoulder by the school district to grant or deny any request that is made by the family. And so as an advocate, every time I go to an IEP meeting, I always ask, who's our administrative designee today? And I often have the principal say, I'm the administrator. And I always say, that's lovely, but I don't care about you. Of course, I don't actually say that. But who is our administrative designee? Who is the person who's going to grant or deny any requests I make today? And the reason why we want to know who the administrative designee is if you're, in an IEP meeting and you're advocating and you are, trying to convince them to give your kid a service, and you've got some of the people in the room kind of nodding their head yes, and you're like, yeah, I'm doing it. But if your administrative designee is not one of those people nodding, then you still have work to do. So kind of knowing your audience, knowing your decision maker can be really important. So we have a couple questions coming in. After the webinar, will the documents be made available to us for reference? Yes, I'm going to send English and Spanish versions of all of these tools to Katie so that she can share them with you guys. And I'm giving you the Spanish ones not because I think you need them in Spanish, but just in case you're working with families who need access to Spanish tools, you'll have them. And then next question, what if the old district does not forward the IEP to the new one? That's a really good question. Number one, under the law, they're required to do it. For a typical kid, they're supposed to move the records within, I think, 10 school days. For foster or probation youth, the new district is supposed to request the records within 2 days of enrollment, and the old district is supposed to send the records within 2 days of the request. So that's a 4-day timeline. What do you do if that doesn't happen? And by the way, this doesn't happen all the time. So an ed rights holder has a right to access all of a child's education records. And so the ed rights holder can, call up the school and ask them to either send the ed rights holder a copy or to send the new school district a copy. One of the things that we use as advocates before we start working with any child or family, we get all of their records from all of the schools they've ever attended, and that can be a lot of schools. And we just create like a black 3-ring binder, and we put them all in chronological order. So we just hold those records all the time. So if you're working for a kid who has demonstrated instability, who's moved around a lot as their tutor or their advocate, making sure you have a copy of all their important documents, including their current IEP, can be a really helpful tool as well. All right. So another question, if the child is at an emergency shelter where the location is confidential, how can you provide assistance in requesting and obtaining an IEP documents from previous schools without providing the new school information? So that's a super tricky one. And obviously very important, right? If things need to be kept confidential, there's really good reasons for that. One of the things that I would think about is revealing a school's location does not necessarily reveal the location of the underlying family, right? So schools and school districts cover kind of broad areas. And so you could say to school A, please request records from school B without revealing anything about the confidential location of the family. That's one option. Another option is to just go directly to the school, get the records from the school, and then kind of transfer them over yourself. So that way, less information is revealed that would be putting the child and the family in danger. Good questions, you guys. Okay. In addition, who else is required at IEP meetings? Anybody who has assessed the child and is reporting on that assessment has to be there. Anyone who's providing services to the child has to be there to discuss those services. And if the ed rights holder's primary language is not English, an interpreter or translator is also a required team member. Now, who are optional members of the IEP team? That can include the parent or current caregiver if those people are not the ed rights holder, although the ed rights holder gets to control whether they come or not. Social workers and probation officers can come, foster care or homeless liaisons can come. And really, the ed rights holder can invite anyone to the ed rights holder who knows about the child's educational needs. So I'll give you kind of a silly example. We had a client once who went to an after-school kind of tutoring program at their religious institution. And so the priest in like full, beautiful regalia and frock came to the IEP meeting because that person worked with that kid every day after school on their homework. They had relevant knowledge about their education. And so at the ed rights holder's request, that person attended the IEP meeting. All right, so now we're going to move on to present levels of performance and annual goals and objectives. And these two things kind of go hand in hand. So a present level of performance is how the kid is doing in a very specific area. It's a baseline, right? The kid is doing this. And then the annual goal and objective is where do we want that child to be a year from now in order to improve their skill level. And so for both present levels and annual goals and objectives, you need one in every single area of need. So that means they have to be comprehensive, right? We want one in all areas of need, but they also have to be really specific and measurable. So, Johnny is struggling to read, not very specific, but Johnny's in the 3rd grade and is reading at the 1st grade level. That's really nice and specific. We can actually be even more comprehensive than that because reading has multiple component parts. One part of reading, often called decoding, is the child's ability to actually sound out the word. So cat is cat. That's reading decoding. Another part of reading is reading comprehension. Is the child able to understand what they're reading? So you could have a present level and a goal in both reading decoding and in reading comprehension. And as advocates, one of the most important things we do is make sure that we have goals and objectives and present levels in all those areas. And I will tell you, goals and objectives and present levels are not fun. They're the most boring, like give me a headache part of an IEP. I don't enjoy it at all. But it's really important. An IEP is built like a pyramid. And by that, I mean, you only have a right to the classroom and the services that you need in order to achieve your goals. So you have to have goals in all areas of need to get the services and classroom placement that you want. So for example, if you want your child to get speech and language services, you have to have speech and language goals. And if you want your child to get a lot of speech and language services, you need to have a lot of speech and language goals. Same thing for academics, same things for behavior, same thing for, social emotional needs, etc. I can't tell you how many times I have families say, my kid really needs a behavior aid, but I look at their IEP and there's no goals about behavior. Well, it's going to be impossible to get that behavior aid unless you have multiple goals around behavior. So that's one of those reasons why being really specific and measurable and comprehensive is really important. So this is a non-exhaustive list, meaning there's so many more things you could potentially have here. But here's a non-exhaustive list of areas where you might have needs. And so just for example, in reading, we've got decoding, comprehension, fluency, phonics, sight words. Social emotional behavior. You can have time on task, social skills, depression, temper tantrums, following directions, attendance, homework, or classwork completion. And really, the law says you have to have a goal for every unique area of need. So very often what I hear in an IEP meeting is, well, we don't need to write a goal in that area because we're going to work on that in the classroom anyways. And so my response to that is, well, when you just went over your assessment, you told me the child could not do that. That makes this a unique area of need for this child. And the law requires us to have a goal in every area of unique need. So they can't really say like, no, that's not an area of need because they've actually just told you in their assessment that's an area of need. The other thing I often hear is, well, we don't want to have too many goals because that will hurt little Johnny's self-esteem. And my internal monologue is, Johnny can't read, so he can't read his IEP, so he definitely is not going to know he's failing all of his goals. My external dialogue is, well, you just told me in your assessment that that's an area of need, and the law requires us to have a goal in every area of need. You basically just come back at them with the law. Again, you have to have a goal in every area of unique need, and that is the tool you can use to build a lot of goals, even though it is a torturous process. And then you use that as evidence to get your services. Now, I can't tell you how many times I have been able to effectively use, for a typical kid, you walk into their IEP and they have a reading goal, a writing goal, and a math goal. If you've ever been to an IEP, you know that's the deal. I can't tell you how many times I've had kids who don't have a math disability. So I'm like, why do we have a math goal? But they have 18 different types of reading disabilities. So I'll sit there for 3 hours and write 18 different types of reading goals. And then when they say they just want to give the kid 30 minutes a week of academic supports, and I'm like, that's not going to fly. We now have 18 goals in reading. And then the teacher's like, oh yeah, we need more services. So you've actually turned a team member, a member of the IEP team, you've kind of gotten them on your side because now they're responsible for meeting all of those 18 reading goals. And when you ask for more services, they're going to be like, yeah, we need to do more services. So, it's kind of counterintuitive, but that is why they fight so hard on goals, because they know that once they have goals in those areas, they're actually accountable to having a child meet those goals. And then they're more likely to give you more services for that. So because they know that, they're going to fight you really hard on the goals. But if you can get over that, that hurdle, you can really be an effective advocate for kids. All right, I'm going to pause, take a deep breath, see if we have any more questions coming in. Take a sip of water. All right, let's keep going. Oh, we had a question come in. Okay, so we've got a foster child receiving mental health services at home and his non-public school. I find this conflicting. The school clinician seems to be more invested in targeting home issues instead of school challenges. Can I request to stop services at school and just continue services at home? So this is a really great question. So an ed rights holder can choose to accept or not accept anything in the IEP. So think about the IEP as an a la carte menu. You can, an ed rights holder again can choose to accept or reject anything. So the simple answer is yes, of course you can stop school-based mental health services. The thing that I would think about here, if the child's in the MPS, non-public school, they probably have significant needs. And if they're getting school-based counseling and home-based counseling, again, they probably have significant needs. So if the school clinician is focusing on the wrong thing, I would go back and look at the IEP goal. If the IEP goal is about home stuff, you just have the goal wrong. So go back and rewrite the goal to have it be about school issues and whatever those school issues that you want to address. Maybe the child is, doesn't have coping skills to deal with frustration and therefore not getting their work done. So you could have a goal to build coping skills and complete their work, right? So if you can find what the school-based issue is, write the goal specifically around that issue, then that clinician is forced to address that issue. And really can kind of stay out of the home stuff. Now, I understand that's not always how it works out. And so, yes, you can absolutely kind of refuse that service. All right, another question we have, does this count for San Bernardino County as well? The answer to that is yes. These laws that I am talking about count for all of California, and they also count depending on, there are some slight variations, but this is actually federal law. And so these definitely count for those too, for anywhere in the nation. Okay, so now we're going to talk about placement. And this is really classroom placement. There is a requirement under the law for kids to be placed in what's called the least restrictive environment. And that means we want kids educated with their non-disabled peers as much as possible while still meeting their needs. And so there is no one least restrictive environment. A least restrictive environment is a student by student analysis. So student A's least restrictive environment is going to be different than student B's least restrictive environment. So I very often go to IEPs and they say, well, we can't place you there because that's not the least restrictive environment. And my argument to that is, well, this child's least restrictive environment is X because blah, 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 right? So anytime you hear like, that's not the least restrictive environment for all kids, you know that what they're saying is not right and not true. I think it's important, when we're in this world, kind of thinking, I think, really seriously around racial justice issues these days. It's important to know where this least restrictive environment comes from. This mandate in the law, kind of came shortly after the civil rights movement of the 1950s and 60s, and was coming based off of, issues in school segregation. And so what happened was kids were being segregated by race in school. And when, Brown 1 and Brown 2 came out and said that was illegal, school districts tried to circumvent that by putting children of color in segregated classrooms because of quote unquote their disability, or putting them on like vocational tracks instead of college tracks, again, quote unquote, because of their disability. And so our least restrictive environment mandate has been used in the past to get around school desegregation by race. And so there are kind of underpinnings to this that are important to understand. There's a reason why kids of color are overrepresented in segregated classrooms to this day. That's one of, although not all of, the reasons why I am personally very skeptical of special day classes. Another reason is they don't really teach a whole lot there, and kids don't learn a whole lot there. But those two things are really intricately intertwined. And so I think it's important to kind of at least mention that background and history as well as current. So let's go through what our placement options are. Our first option is gen ed. And this is where kids kind of already are before they get an IEP. There's some pros here. Kids can learn through positive peer modeling from their non-disabled peers, good study skills, academics, social relationships. The con is if the child was doing fine in gen ed, they probably wouldn't need an IEP, right? So there's something about the student's disability that's making accessing gen ed without support not work for them. That doesn't mean kids can't remain in gen ed with supports or partially in gen ed, but there's typically a reason why gen ed all by itself is not appropriate for kids. So next, we have what's called typically Resource Specialist Program, RSP, RST. There's also kind of some new nomenclature called Specialized Academic Instruction, kind of the same thing. But the idea here is that a child typically does not go to a segregated classroom all day. They're given some type of in-between type of support. And there's a couple different models of RSP. One is collaboration. And this is where an RSP or special ed teacher kind of talks with the kid's gen ed teacher and gives them
Hello, everybody. We seem to have lost Jill. Please, hi, you're back, Jill.
Hi, I am so sorry. I am not sure what happened.
That's all right.
Okay. Sorry, guys. Okay, back to RSP. Okay, so let's talk about ways that RSP push-in can go well. So for example, the normal teacher is at the front of the classroom teaching a math lesson, and the math lesson is, going well. The child is absorbing.
Hi, folks.
Dang it, I am so sorry.
That's all right, Jill. It might be your internet connection.
It is going in and out. I'm not sure why. And I'm in a place where I don't even know where it is to reset it. So hopefully we'll just make do. I'm so sorry.
That is all right. Yeah, let's just keep trying. And if this continues happening, maybe we can wrap it up early, and I'll just make sure everyone has access to the documents and to your contact
Yes,
information in case it happens continuously.
you got it.
Okay.
Okay, so the other option we have is RSP pull out. And what that means is a child comes out of the gen ed setting for a certain amount of time per day or per week, and they go into a smaller classroom with a special ed teacher where they can be retaught, and kind of fill in holes. If you have a kid who's academically, more than a year behind, so maybe a couple years behind, RSP pull out can be really effective. The other thing I've seen problematically with RSP pullout is they want to do like 30 minutes a week. And if you have a kid who's 4 years behind, pull out 30 minutes a week doesn't work. You need much more time than that. An hour a day, 2 hours a day, 3 hours a day. So you can definitely ask for more there. So then the other option that we have is a special day class. A special day class is, a pretty restrictive setting. Kids are segregated in a classroom. There's no gen ed peers. There's no gen ed teacher. They're not typically teaching gen ed curriculum. Those curriculums move slowly. They do a lot of accommodations. So I'll just give you kind of a silly example. In high school, I remember reading Romeo and Juliet. In a special day class, they want the kids to access the content, but maybe they can't read a special day. They can't read Romeo and Juliet. Maybe they watch the movie. So that's just one example of how they try to give kids access to the same content, but it's not really academically rigorous. The other thing that I've really often seen is kids with learning disabilities that with some, pretty significant RSP could catch up and could be in gen ed and could be on a college track, but they get put in a special day class and then they stay there their entire educational career. And, I have kids graduate all the time who don't know how to read. And that is really problematic for me. So I am typically very cautious about putting anyone in that segregated special day class. Both because of its kind of racial undertones, but also because of the lack of academic achievement I see coming out of those classes. I certainly would recommend that an ed rights holder go and observe either in person or these days remotely to see what does that classroom look like? What are they doing in that classroom? And is that the right fit for your child? And there's lots of kids that are significantly disabled, so that is the right fit. There's also special day classes that are well designed. So, I don't want to say there's never that. There are some. So that can be a good option as well. One of the things that I think is most important that I think about as an advocate, I almost don't really care sometimes whether I'm in an RSP class or an SDC class or I'm receiving some type of specialized academic instruction, if my kid has some type of academic delay or learning disability and they're offering an academic intervention. So the law talks about there are academic interventions, for example, let's say a reading intervention program that's been scientifically proven to be effective in teaching kids with disabilities how to read. I don't care if they give that to my kid in RSP or SDC, as long as they give that to my kid. And so that's something you can definitely think about, asking for, a reading intervention or an academic intervention program. I always typically ask, do you have any reading interventions here? And they often say, we use Houghton Mifflin. That's the curriculum approved by the state. That's not a reading intervention. That's a curriculum, which means it's a set of books that you can buy that a teacher can teach off of. That's very different than an intervention program. An intervention program, kind of like testing, has to be given in a very specific way. It's scientifically proven to be effective if given in that certain way. So maybe it's required to be an hour a day, for example. And those interventions are things you can Google, you can look them up, you can see the study where it shows that it was effective, and you can see the requirements. So a teacher has to have at least 100 hours of training in it, and it has to be given 2 hours a day, right? And so those are things that you can ask for, you can think about, and then you want the IEP to reflect, my kid is going to get an hour a day of a reading intervention program called, fill in the blank, by a teacher who has X amount of hours of training in that program. So you actually write all of that into the IEP, and that means your kid has a right to it. Okay, so our most restrictive setting is a non-public school. Non-public schools are outside of the public school system, but they are paid for typically by the public school system. And the idea here is nothing in the district has been able to meet the child's needs. And so the district has to pay to send the child somewhere else. Now, this is different than a private school. It's certainly different than a private parochial school. Non-public schools are certified by the California Department of Education specifically to educate kids with disabilities. And just like everything else, there are amazing non-public schools and there are horrible non-public schools. The good and the bad, I certainly know some that I like and some I don't like, but the best way to figure out if it's a good one or a bad one is to have the parent or ed rights holder go and observe it and visit it and, see what it looks like. If all the kids are getting yelled at and screamed at and kicked out of the room, it's a bad one. If all the kids are engaged in their learning and eager and, love their teacher, then it's a good one, right? So the typical ways that you tell when you got a good school, good classroom. Okay. So if you've got any questions about placement, I'll look at those now. We did have a question come in. What's the difference between a 504 and an IEP? So the difference between a 504 and an IEP is both not much and a lot. So by not much, I mean, the crazy thing is the eligibilities between an IEP and a 504 are pretty similar. For a 504, you don't have that list of like 13 eligibilities you have for an IEP. But what a 504 says is that you have a disability that makes it hard to access your education. And in an IEP, you've got that list of 13 disabilities, but those are just different specific ways that disabilities make it hard for kids to access their education. So in that way, they're very similar. They're very different in that an IEP has to be held once a year. An IEP has goals that create accountability that the school district has to meet. And an IEP provides placements and services. Typically, a 504 plan doesn't have goals, doesn't have to be held every year, and doesn't have to provide any type of placement and services. So I like to call the 504, kind of the ugly redheaded step sibling of the Cinderella IEP. Nothing against redheads. I love them. They're great. But you get a lot less out of a 504. And if you've ever been in a situation where a school says, oh, you have ADHD, you don't need an IEP, you just need a 504 plan, that's because they're putting you into the less expensive route where there's less accountability on their part. So that kind of tells you more than you need to know about which one's better, which one gives you more. Good question. All right. So now we're going to talk about services. There are a wide variety of services that kids can get depending on what their needs are. And remember, you build proof of that need by having good goals in those areas. But you've got speech and language, occupational therapy, adaptive PE, physical therapy, school-based counseling, audiological services, vision therapy, behavior aids, transportation, extended school year, assistive technology, and educationally related mental health services. So what do you need to know about services? Number one, you build your right to services by building your good goals. So that's really important as well. Number two, everything in your IEP, but most especially your services, need to be documented in writing in the document. I can't tell you how many times I have a parent come to me and say, they promised to give me a 1-to-1 aid. And then I look at the IEP and there's nothing in the document in writing about an aid. And I have to tell the family, you don't have a right to an aid because it's not in writing in the document. So one of the things that I do as an advocate, I read the entire IEP before my ed rights holder signs it. I especially read very closely where it talks about placement and services to make sure that everything that they promised me is there. And it's a pain for sure, but it's really important. The other thing I think that's important about placement and services is that we have to talk about what's called frequency and duration. Now, frequency and duration should be written, for example, as you're going to get speech and language therapy 2 times a week for 30 minutes each for a total of 60 minutes. Now, the reason why I think it's really important that services are written weekly as opposed to monthly or yearly is because then you know the kid has a right to get that service every week. And for example, something like speech therapy or occupational therapy or mental health counseling or whatever, that is something kids need all the time. If it's written as monthly, for example, you're going to get 240 minutes a month of speech therapy, it's the same amount. It's still an hour a week, but if it's written weekly, you know the kid is going to get an hour every single week. If it's written monthly, they could do 4 hours of speech in one day and then not get speech therapy for another 29 days. Even worse, when it's written yearly, and I have seen this more and more recently, you're going to get 3,900 minutes of speech a year. That allows the district to do it whenever they feel like. And that takes away from the efficacy of the service in a way that is 100% designed to benefit the school district and 0% designed to benefit the child. The other reason why they do the 3,590 minutes a year is that, and I see this all the time, we have a 36 weeks school year. That's 180 days divided by 5 days a week is 36 weeks. What I will see, when they do something like that is when I divide, 3,590 minutes a year, I divide it by 36 weeks, it only ends up, for example, being 45 minutes a week, not the 60 minutes a week that they promised me. And that, again, just allows them to miss days, to say, oh, sorry, we had an IP this day, so you don't get your service. Again, it's all about the convenience of the school district and not about what is appropriate for the child. So I typically throw a little bit of a hissy fit when I get these like monthly or yearly written services. And the response to that is the IEP is about what is appropriate for this child. Doesn't everybody in this room agree that this child needs speech every week? And they're like, yeah, but sometimes we have meetings and parent-teacher, blah, blah, blah. And I said, that's not about what's appropriate for this child. That's about your convenience. We have to write an IEP about what's appropriate for this child. Don't we all agree that the child needs services every single week? And that's one of the ways you can try to get around that. Doesn't always work, but it's one of those things that you can do. Okay, you probably are sitting out there with a whole lot of questions about, but it's COVID and no one's getting anything. And we're going to talk about that in just 2 minutes. Bear with me here. So let's just talk really quickly about IEP consent. We talked about that a couple of minutes ago. Everything in the IEP is available to the youth and available to the ed rights holder. And you've probably done a lot of work and advocated to get all the things your kid needs in the IEP. What's important to know is that, again, it's like the a la carte menu. The ed rights holder can consent to parts of it and not consent to others. And the part that's consented to has to start as quickly as possible. And that is required under the law. The other thing that you can do, and we do this all the time as advocates, is we say something like, I consent for purposes of implementation only, but I don't agree that this is appropriate. So for example, if I'm at an IEP where they've written services for 3,590 minutes a year, and I think my kid actually just needs an hour a week, I'll say, we're agreeing to speech services for implementation purposes only. We don't believe that the yearly delineation is appropriate to meet my child's needs. My child needs 60 minutes a week. So we just write it out. And what that does is it allows the speech services to start, which is really important, but it also kind of marks the disagreement. And so if you come back in 3 months or 6 months or a year and say, my kid is not progressing, you need to give them more services, they can look back at the prior IEP and be like, oh yeah, this parent's been asking for this for a while. So it kind of just builds a paper trail of what you're asking for, which makes it a little bit more likely that you're going to get it next time around. So that's really important as well. The other thing we need to know about IEP consent is that there's a million different situations in which the school district holds all the power. They get to decide whether to assess or not. They get to decide what to offer you in the IEP. And you can advocate to the best of your ability, but sometimes it feels like you're hitting your head against the wall. And if you've ever been to IEPs, you know what I'm talking about. It's just like, but my kid desperately needs this. We don't have that, right? So it's a difficult situation to be in. But once the ed rights holder consents to the IEP, that you basically have that service for life, and not really for life, but Once it's in writing in the IEP, and once the ed rights holder has signed it, they can't ever take it away unless the ed rights holder agrees. So for the first time in this entire situation, it puts the ed rights holder in the power kind of negotiating position. So I'll just give you an example. If you have an IEP that gives you an hour a week of speech, and then, however much time later, 6 months or a year later, you go back to another IEP and they say, your kid is doing so great, we want to reduce their speech to 30 minutes a week. All the ed rights holder has to do is say, no, I don't agree to that, and put in writing on the IEP document, I don't agree to a reduction in speech, and then the speech stays, which is amazing. And this is for everything. This works for aides, this works for non-public schools, this works for placement, service, accommodation, this works for everything. So that's a really important thing to know as well. Okay, so let's talk COVID. So we have talked about the fact that lots of districts, especially as we kind of, things were easing up and then we went back into this new surge, lots of districts have stopped, if they started, have stopped doing assessments. We also pretty much across the board know that kids are not getting everything in their IEP. So for example, if you're in a special day class where you're supposed to get 6 hours a day of specialized academic instruction, kids are not getting that. If they're lucky, they're getting 2 hours a day of live synchronous instruction remotely. So that's a violation of the IEP. There's lots of kids who are supposed to have a one-to-one aid who are not getting it. That's a violation of the IEP. If your kid is supposed to be getting 60 minutes a week of speech and they're only getting 15 minutes because that's all your kid can do because they're 6 and they can't be on a computer 1,000 hours a day, that's a violation of the IEP. So you have lots of different IEP violations, either in like the amount of time they're supposed to be getting and they're not, or they're getting none of the service because the service has to be in person, or they're getting some like kind of not true to form service. So like RSP push-in. How is RSP push-in working in like a live Zoom? That's not going to happen. Or if it does, it's not working well. We also have kids whose disabilities are preventing them from accessing what the district is offering. So kids with autism can't be in a Zoom for 5 hours, right? Or, we certainly heard from LUSD, we're not giving any speech therapy because our providers are not trained in telehealth. So we're going to post speech exercises on Classroom Dojo, and that's going to be speech therapy. That's a violation of the IEP. So you have all these massive violations of the IEP. So what do? Whether it's a violation of the IEP or the district refusing to assess, and this applies to COVID, but also applies outside of COVID as well, you have a couple of different options. Your nuclear option is to file a lawsuit against the school district, and I would highly recommend that you get an attorney to help you do that. You're not, because let me tell you, they're going to have a high power attorney and you're going to lose unless you have somebody fighting on your side too. The non-nuclear option is to do what's called a compliance complaint. And these are filed with the California Department of Education. And there's 2 simple examples here. Failure to follow the timelines in an assessment. So for example, they didn't provide a written response to your assessment request within 15 days, or they didn't do your assessment within 60 days after getting ed rights holder consent, or the kid is just not getting what's in their IEP, what they have a legal right to in their IEP. So you can file a complaint, you basically say what the violation is, you send it up to the California Department of Education. The CDE has 60 days to investigate and basically find whether the district is in compliance or not. And if the district is out of compliance, to order you a remedy. For example, order them to provide all of your missing speech therapy. Now, you don't need an attorney to do this, but we have been doing a ton of these and we've been winning every single one that we are filing. We are getting districts ordered to do assessments. when the family wants it, for example, if a kid is supposed to have a one-to-one aid and the district is not providing it, we're getting the district ordered to pay a private agency to provide the aid in the home. We're getting private speech ordered, private OT. We're getting really good results with that. If you are working with a kid with an IEP, it is very, very likely that the kid is not getting everything that they are entitled to. So this is a really great way to be able to advocate for them. Okay, so that is pretty much the end of my content. I am so happy to answer any more questions you have. I'm also going to put my personal email in the chat box, but I'm going to give you a caveat here. If you have just a question, like, I remember you said there was a timeline for an assessment, but I don't remember what the timeline was. So it's like a question about the law and what your rights are under the law. Email me. I'm happy to answer that question. If you want our help with a case, don't email me, because I'm going to have to send you back through our intake process. And if you remember from the beginning, our intake process, you can either give us a call during business hours and we'll take you through the process, or you can go onto our website, all of which I put into the chat, and fill in an online referral, and then we'll take you through our entire process. Then we can potentially help your kid's case. Okay, so we had a question come in. School administrator has made slandering remarks and shared negative emails about this parent to others. Behavior has interfered with services, communication, and exploring an alternative setting. She has a local advocate. He felt the same way. Can the Office of Education help me explore alternative academic settings? Okay, so this is a really interesting question. I think ultimately, whether you get the district to pay for a different setting, for example, a non-public school, you have a couple of options. One is just to get the district to give it to you, which is hard. Number two is to get an advocate or an attorney and to go through the IEP process and try to get the district to give it to you. And number three is to sue the school district and get a judge to order the district to give it to you. I think that it is the California Department of Education with a compliance complaint can typically will order like compensatory services. So for example, if your kid was supposed to get an hour a week of speech for the last year and didn't get any, they can order 36 hours of compensatory speech. It is possible, but I don't think I have ever seen the California Department of Ed order like a different placement. That's just kind of not the role that they have. And I just think that they're very uncomfortable doing something like that. But really good question. Okay, any more questions? I'm so glad we got through my internet connectivity issues. I'm so sorry for that. And thank you guys all so much. I don't know, Katie, if you want to come back on.
I'm here. Hi. That was awesome. Thank you so much. Oh, you know what? It looks like we have one more question.
Yes.
Actually from a staff member.
I saw that just come in. Okay, so if a student is having behavioral issues, for example, physical outbursts, and a parent believes an IEP assessment is needed, can a school kick them out, suspend them due to these outbursts? So really good question. So one of the situations that we typically find ourselves in is we're kind of on the cusp of getting an IEP, but a kid has a long history of behavioral issues, and those behavioral issues are kind of ongoing. So here's the law around this. If you have requested an assessment in writing, and the school is trying to take kind of disciplinary measures, those disciplinary measures have to stop. So for example, if you've requested an assessment and then they're trying to kick the kid out, AKA expel them, they're not allowed to do that. They have to stop the expulsion proceedings, do the assessment, do the IEP. If the child is found eligible, then they have to do a special IEP called a manifestation IEP, where they say, is the behavior that's leading to the discipline a manifestation or substantially related to the disability? If the answer to that is yes, then they're not allowed to discipline the kid because they're disciplining the kid based on their disability, which is illegal. So they have to go all the way through that process. If they then find that the answer is no, then they are allowed to discipline the kid just like any other kid because they're not disciplining them based on their disability. So follow-up question, requested an assessment, but haven't requested it in writing, just verbally. So I would strongly recommend that you put that assessment request in writing immediately. And if you can remember approximately when you asked for the assessment and who you asked for it from, I would put that in the letter as well. It's not a perfect solution, but it'll probably get you kind of into that special protected category.
Thank you, Jill.
You got it.
All right.
Oh, so another question. Can a school say they have no funding for the IEP or they have no special education department? So every school, including charter schools that accept any federal money or state money, have to follow federal and state special ed laws. And that is as simple as free and reduced lunch. Every school has free and reduced lunch. That's a federal entitlement. So unless you are in a private parochial school that accepts 0 state or federal dollars, those schools don't have to do it. But anybody else who accepts any money from the state or federal government, which almost all schools do except private religious schools, then they do in fact have to comply with all of these laws.
Awesome. And for any other questions that people might have, we want to round it out here right at the 2 o'clock mark. You know, for the simple questions, Jill did say that you can go ahead and contact her. We're also going to make sure that this webinar is available, a recording of it is available on our website in a few days. And in addition, we actually have a little section on our website. It's the same page where the webinar will be posted, but it's a little further down. It's a whole section that has a number of documents and resource lists regarding advocating for your students' educational rights. So there's a few extra tips and community resources in there as well, because I know we serve many different regions and counties as well. Yeah, so please keep an eye out. We'll be sending up a follow-up email in just a few days notifying you once the recording has been uploaded to the website, and we will make sure you all get the appropriate information that goes along with it. Thank you so much, Jill, for bringing this sort of righteous energy to this topic for us. Yeah, I appreciate it very much. And for those of you who are attending right now who are tutors, please know that you can log this as non-tutoring hours on our tutor portal. So if you're looking to get extra hours, this counts as 2 hours. And I believe that is it. So thank you all so much for attending. And thank you again, Jill. I really appreciate this.
It was a pleasure to work with you all, and we look forward to helping you and your kids in the future. Please just let us know how we can do so.
Absolutely. Thank you. Everyone have a lovely day.